Our next speaker asked for a short introduction. There's actually heaps of stuff about him. His publicity team are very, very active, and they've given us lots and lots of biographical information that you can read about him. So I'm just going to give a very, very short introduction. Would you please warmly welcome the rock star of asylum seeker, legal barristering stuff, Mr. David Mann.
Perhaps I should have gone for the longer version. Let me start by expressing my sincere gratitude for the invitation to speak to the Progressive Law Network at your conference, and also to, at the same time, to congratulate you on the establishment of the network and its ongoing work. Put simply, ideas matter. Debate and discussion and ideas matter, and progressive ideas matter. I want to talk today about the question of to what extent we deny asylum seekers a fair go before the law in this country. And on this point, let me start with a story. In August last year, as I was cooking for the kids on an early Saturday evening at my home in inner city Melbourne, just up the road, I received a call for help. It was a distress call relayed through a young Canberra-based legal aid duty lawyer. He was probably awaiting his first call to advise someone arrested on a drunken disorderly charge. Instead, he told me he'd just received a call out of the blue from a group of men incarcerated on Christmas Island wanting advice. These men, some of them from Afghanistan, feared being expelled to Malaysia. The matter was urgent. How urgent was unclear, but there was a sense that expulsions could happen as early as Monday. Now, this lawyer had no experience in refugee law, but he had the presence of mind to send a message out to legal networks in Australia, which may know where to find a refugee lawyer. And that's how the call for help landed on my kitchen bench. Now, later that evening, I spoke by phone with some of the Afghan men seeking help. They were petrified. They explained through the aid of interpreters that they had recently arrived by boat in Australia seeking protection from persecution in their homeland, only then to be told by Australian officials that they would not be allowed to seek protection in Australia as refugees. Instead, they were to be expelled to Malaysia. They told me they feared suffering severe harm in Malaysia, and they also feared deportation from Malaysia to life-threatening harm in their homelands. Now, the group of 36 men sought two things. First, that they not be expelled to Malaysia, and secondly, that they be allowed to stay in Australia and to seek refugee status here. The brief had an extra complex twist. One of the men I spoke to that evening, Mr. Shah, who became the lead plaintiff in the High Court action, and who may one day become known as the Eddie Mabo of refugee rights, Mr. Shah sounded even more concerned and even more distressed about the plight of the unaccompanied children and families, that is, mothers and their children, who are incarcerated separately and out of reach on Christmas Island at the same time. They too wanted legal help, and he pleaded with me, "Can you please help them, Mr. David? Please do what you can. They need help like us." My efforts that evening to speak with the unaccompanied kids and the mothers failed. Immigration Department officials refused access, despite my repeated requests for access. I was told that they, that is the Department of Immigration and private detention centre operators, were, quote, on alert, unquote. Alert for what, I asked? Well, if someone says something like lawyer, I was told. 6 of these unaccompanied children were only able to join the High Court action because the next morning, on Sunday morning, Mr. Shah was able to recall their names from the boat journey and agreed to act as their litigation guardian. At the same time that he agreed to act as litigation guardian, officials from the Department of Immigration, that is, officials from the department of their primary legal guardian, the Immigration Minister, were blocking access. All happening on Australian soil. So this was the brief from start to finish. As lawyers, we were asked to provide legal assistance to challenge the lawfulness of their expulsion, and secondly, to secure assessment of refugee status for them in Australia. And that is what we did. Thank you. The brief was not to challenge the policy, nor was it the task. There was no such conspiracy. So that Saturday evening and the following Sunday morning, a legal team was assembled comprising some of the finest in this field in Australia, such as counsel Debbie Mortimer SC, Richard Nile SC, and leading law firm Ellens Arthur Robinson, all acting pro bono. Despite their low profile in the case, much of the intellectual and forensic force for the case was driven by Debbie, driven by Richard, and Chris Walker and other counsel. Now, the fee-charging exploits of lawyers are, of course, legendary, and less well known, I think, is the rich tradition of pro bono assistance by some of the finest lawyers in the country. And it matters deeply. Within 24 hours at 6 p.m. on Sunday evening, we were before the High Court of Australia in Melbourne seeking an urgent injunction to stop the government from expelling any of our clients to Malaysia. And it is here that we learnt precisely how urgent the matter was. That 16 of the men were to be put on a plane at 11:30 a.m. the next morning, Monday morning, to a place with a long-standing track record of serious mistreatment of refugees and a conspicuous absence of any legal protections to guard against abuses that so many others had and continue to suffer there. His Honour Justice Hayne granted an interim injunction that evening, effectively preventing the planned removals on Monday morning, and on Monday afternoon, that is the following day, he extended the injunction pending the determination of the matter. That's how close these people came to losing their rights. And when you think about what's at stake, no less than life or liberty, protection from brutal abuse, it reminds us of how precarious access to lawyers and the law can be in this country. About 3 weeks later, the High Court emphatically ruled by a majority of 6-1 that the government's proposed expulsion of these people to Malaysia was unlawful. And I found myself, with other members of the legal team, crowded around a telephone in barristers' chambers in Melbourne, just around the corner, telling 6 unaccompanied kids and 36 men incarcerated thousands of kilometres away that they'd won their case. That the court had said that the government was not allowed to expel them to Malaysia. Now, for these very vulnerable people who are unlikely to have ever had anyone independent, let alone the law, spring to their defence through the trauma of their pasts, the sense of relief was deep and it was overwhelming. The essence of the court's ruling was that the Minister's declaration of Malaysia as a suitable place to send asylum seekers for processing was invalid, that is, unlawful. That under Australian law, the proposed expulsion of asylum seekers to Malaysia is not lawful, and that this is because Malaysia does not provide adequate legal procedures or protections for refugees there. It also reminded us, the case, I think, that whoever you are and wherever you're from, you can call on the law for protection in this country. Almost 10 years to a T after the Tampa incident, how did it come to this? Well, briefly, to understand the context of the recent High Court challenge, we need to rewind a decade to the time of the Tampa. Now, the facts are notorious enough for me not to provide a full recount. Suffice to say that, contrary to past practice, 433 asylum seekers en route to Australia were refused entry and instead expelled to Nauru for processing of claims and warehousing. The so-called Pacific Solution policy spawned the prototype of offshore processing. In action, it involved 2 key parts. First, the first part was exclusion. That is, exclusion from seeking refugee protection under Australian law. And secondly, the second part was exile. That is, exile to another country in the region, Nauru or Papua New Guinea in that case, for assessment of refugee status and warehousing. In policy terms, The rationale was driven by the imperative of deterrence of people coming by boat, something familiar to this day. Deterrence of people who were seen to have arrived by way of what was called secondary movement, a term otherwise referred to less fortunately by some as queue jumping. The idea was that these people had forsaken protection elsewhere on the way to Australia and could therefore be penalised. Now, the fact that there were no real queues and no real protections accessible in the region en route to Australia didn't get in the way of pursuit of this policy. Crucially, the policy was avowedly said to be fully consistent and compliant with Australia's obligations under the Refugees Convention. Expulsion of asylum seekers must not and does not breach our treaty obligations, we were told time and time again. It is in this context that Section 198A of the Migration Act was enacted by Parliament. This is the provision introduced by the Howard government at that time, still on our statute books, which empowers the Minister of the day to declare a country to be suitably safe to transfer asylum seekers to instead of leaving them stay in Australia for processing. It is this provision that was used to declare Nauru and Papua New Guinea to be suitably safe. And it is the same provision which was used by Minister Chris Bowen on 25 July last year to declare Malaysia to be suitably safe for expulsions. It is this provision which became the focal point of the High Court challenge. This law requires that a declared country provide three key things. In other words, this provision, enacted around 10 years ago, set out some limits in our law about transfer of asylum seekers. And these are the three key limits: that there be access to effective procedures for assessment of protection need elsewhere. Secondly, that there be protection. And thirdly, that the country meet relevant human rights standards. The words, I think, captured the claim to compliance with the Refugees Convention in a sense, and inscribed a sense of obligation to asylum seekers which we may now perhaps see as traditional or conventional in a way which may have been taken for granted for some time. But the policy of Pacific expulsion constituted a key foundation of the architecture of one of the toughest and most extensive anti-asylum seeker systems in the Western world. From a human rights perspective, it was a strong contender for Western world's worst practice. Key features included mandatory indefinite detention, temporary protection visas, the Pacific solution, naval repulsion of asylum seekers by boat, and excision of Australian territory to stop people seeking asylum in Australia at all. It was a graphic example of a bigger, more pervasive problem. And that problem is this: that immigration policy and law has become aberrant when viewed in light of the Australian legal system. The suite of policies excised decision-making about the fate of people, and even the provision of legal advice to them, from the ordinary mainstream Australian legal system, and constituted a radical deviation from the application of well-established normative legal principles, which are really the golden threads of our legal system, such as the application of the rule of law, procedural fairness, access to legal advice, access to the courts, habeas corpus and anti-discrimination principles. It also failed to comply with core international human rights principles, such as the prohibition on arbitrary detention. And it perpetuated rather than minimised harm.